This is Bradley Phillips. I'm a criminal defense, personal injury, and traffic ticket attorney here in New Orleans. Not going to waste any time today, going to get right into it because what we're talking about is your criminal case from arrest through appeal in under 5 minutes. So ready, go. So what happens when a person is arrested is you get arrested in either one of two ways. Either by a warrant, so the police, they come, they investigate a complaint, they develop you as a suspect, and eventually they create an arrest warrant, they submit it to a judge who signs it, and a warrant is issued for your arrest. The second way you get arrested is police, maybe they stop you in the car, they have some reason to approach you because they believe you are committing a crime or have committed a crime. They investigate and they decide on the spot that they have probable cause to make an arrest. What happens next? All of this, as well as the bond setting, is going to happen within 24 to 72 hours of your arrest, and that's by law. They have to establish probable cause within 24 hours, and within 72 hours, a bond either has to be set or there has to be good cause as to why a bond has not been set. From there, what happens is your case gets turned over from the police to the district attorney's office and the screening process begins. Now, in some other places, this happens very quickly, but in New Orleans, the screening process can, and Louisiana as a whole, that process can take up to 60 days. So what does that mean? That means if you have been arrested for a crime that doesn't carry a life sentence, so drug possession, armed robbery, anything like that, the district attorney's office has 60 days to decide how or if they're going to charge you. That's what the screening process is. They look at the whole file and they say, okay, we're going to charge this person with X crime. They can charge you in one of two ways. The first is a bill of information. That's just a paperwork they file with the court that says on such and such date, such and such person was doing such and such crime. That's the easy way. The more complicated way, and the way they have to do it if you're facing a charge that carries a life sentence, first or second degree murder, aggravated rape, something along those lines, what they have to do is they have to present your case to a grand jury. Once you're charged, that's when your case gets moved from magistrate to district court. Now, what's significant about that is, first things first, you're gonna go to court, you're gonna plead not guilty, your attorney's gonna file motions for discovery, motions to suppress evidence, things like that. But what is significant about that is now you're going to get all the information that the prosecutor, the police have that says you're guilty of the crime. Basically what happens is plea negotiation, and that can really start as early as arraignment, but that's where your defense attorney is talking with the prosecutor, trying to decide what, basically like a settlement, what can we do to resolve the case in your best interest. From there, if the case isn't able to be resolved, it's going to go to trial. One of two things is going to happen. It's either going to be a judge or a jury trial, and you're either going to be found guilty or not guilty. Guilty could be something of a lesser included offense, so if you're charged with possession with intent to distribute drugs again, you might just be found guilty of possession of heroin. Something along those lines. But if you're found not guilty, it's done, you can get it expunged, you're free to go. If you're found guilty, what will then happen is your attorney will file a motion to set aside the verdict, some other formal things like that, and if the judge denies those, eventually you'll be sentenced. From there, if you don't like the sentence, your attorney can file a motion to reconsider. Otherwise, what will happen is you'll move into the appeals process. Now, the appeals process is where you're going to challenge legal rulings of the court from the pre-trial and trial phase to basically try and say, hey, look, this was against the law, the judge ruled wrong, and because they were wrong, I should get a new trial. My case should go back to the court with the right ruling. If those appeals are all denied, then what's going to happen is you're going to move into the post-conviction phase. That is where you argue things like my lawyer wasn't good enough, we weren't given evidence that we should have been given, or that there's new evidence that has come to light that would prove that I didn't do it. But basically, once that process is completed, if you haven't won there, and make clear, for the post-conviction, doesn't mean your case goes away. What happens is it goes back to the trial court and you get a second crack at it. But if your motions there are denied, there are some federal kind of remedies you have, but that's pretty much the end of the road. I know this has been really quick. We haven't gone into a lot of detail about any of it, but that's really what happens from arrest through appeal, through post-conviction relief when you're charged with a crime in New Orleans. My name is Bradley Phillips. I am a criminal defense, personal injury, and traffic ticket attorney here. If you found this video helpful, please like it on our YouTube. You can follow us on Facebook and Instagram. And more importantly, if you have questions, initial consultations are always free. Give me a call. My number is 504-434-7000, and we'd be happy to answer any questions you have.